The thing is like this, a murder which is equivalent with 103, that is there incorporated as it is, there is no problem in it. But another provision is also included in it. It is called as mob lynching. Another a debatable one, very important one. Mob lynching is a punishment provided in 103 subsection 2. Okay, what it says is, when this is the definition and punishment, when a group of 5 or more persons acting in concert commits murder on the ground of race, caste, community, sex, place of birth, language, personal belief, or any other similar ground, each member of such group shall be punished with the death or with imprisonment for life, and shall also be liable for fine. This is introduced because in the country these honor killings have become the order of the day in the name of the caste, particularly in love marriages where intercaste marriages are being undertaken between the young persons, but those communities are not accepting it and killing the person only on the ground of caste or creed or religion, sex. So in such cases, a more pronounced punishment has been imposed and attached to 103(2). So mob lynching, it is started as mob lynching. A mob lynching provision has been incorporated in 103(2). Okay, this was not there previously. We have only 149, what is called common object, 141 common object definition, 142 member of the common object, 149 constructive responsibility or vicarious liability has been pronounced under section 149. If a member of an unlawful assembly commits an offence in order to furtherance of the common object of that assembly, then each one of them is responsible for that act. In those lines, 149 goes on. So to that extent only we have had. But now a specific offence, if an offence is committed by 5 or more persons only on the ground of these race, caste, community, sex, place of birth, language, etc., the punishment is provided with the death or with imprisonment of life and shall also be liable to fine. Okay. So this is a new offence which has been introduced. Then I already told you section 124A, sedition, has been taken away because that was the legacy of the British colonies. It was felt by our legislators, which will not serve any purpose because now we are a democratic country. Therefore, in those the wording is disaffection towards the established government. It is not the question of disaffection because we can in a democratic country question the government. We can democratically question the government. Therefore, it may mislead, and if 124A is retained in the statute books, therefore with those words, therefore it has been taken away. But at the same time, it was replaced in a different form under section 152 of BNS. It is there, but in a different form. Where it is, the wording used is quite different. If a person or number of persons, in order to affect the sovereignty of the country, if they challenge the sovereignty of the country by their acts, then that would be an offence under section 152. They felt that, legislators felt that questioning the sovereignty is different from causing disaffection in the manner of questioning the lopsided activities of the established government. There is a difference between these two. So 124A will not serve any purpose in this democratic country. Rather, 152 will be there. Attack on the parliament, attack on the very sovereignly established government. That will affect the very sovereignty of the country. Therefore, 152 is now established, is incorporated, which was not there earlier. So this we have to take note of it. Then another important question, it is a controversial one. Because there is a controversy, we have to deal with it. Section 377, please return to slide 12. Section 377, you all know that an unnatural offence, which was defined as whoever voluntarily has carnal intercourse. Please pay your attention. This is a bit controversial. That is why, most importantly, all the advocates, I request, whoever voluntarily has carnal intercourse against the order of the nature. Put that definition. Slide 12. Slide 12. And Sanhita. 377. Okay. The definition goes like this in 377. Whoever voluntarily has carnal intercourse against the order of the nature with any man, woman, or animal shall be punished with imprisonment for life or with imprisonment of either description for a term which may extend to 10 years and shall also be liable to be punished. So unnatural offences were taken as a criminal act as against a man, a woman, or an animal. It was there in the statute books. But all of you know, in the decision in 2019, one SEC, that is, nowadays Singh Johar versus Union of India, 2019, one SEC, criminal, page 1, the apex court, while dealing with the issue of the rights of LGBT, we can call it lesbians, gays, bisexual and transgenders. They are collectively called as LGBT, you all know. The Supreme Court in the judgment held that if 377 is retained in the statute books, it will directly affect the rights of them. By nature has cursed them. Naturally, there are only two sexes, male and female, but a third gender, with qualities of a third gender, God has created. By nature, because of their physical nature, their mental cognitions, they may lead to have a cohabitation with the same sex. This is, the nature has cursed them. We don't have a right to ostracize them by taking their acts as a punishment. I suppose I have clarified this issue. So 377 was struck down in this judgment. Navtesh Singh Johar versus Union of India, 2019, 1 SEC, criminal 1. So 377 is no more an offence. They intended, you have to carefully catch this point, this judgment is only with reference to a free consenting adults. A free consenting adults predominantly for LGBTs, with the hope that LGBTs will have a cohabitation because they are order of the physical and mental attitude. So if two adults consensually had the sex, even it appears to be other society, it is against the nature of the order of the nature, but it is not against the order of the nature because it is natural for them. God has such created them. So it is not an offense they have had. Again, they have given a caution that no, it will be again an offense if it is committed against a person below the age of 18, that is minors, maybe female or male. Understood? This will be again an offense if it is committed against the minors and against the what you call animals. So they have given an exception to these two categories. So the essence of the judgment is an intercourse among the elders or adults, though it appears to us as against the nature, but it is not an offense because there are a third community in the world, third community in our country also, we have to respect their sentiments. Therefore, that is not an offense. But it will be an offense if it is against the minors. Whether consent is there or not is a difficult thing, because minors' consent is not consent in every legal aspects. So also in this one. And against the animals. This exception has been carved out. Now that is the gist of the judgment I have explained you. Now what happened is, the 377 has been totally removed from the statute book by the BNS. Understood? Bharatiya Nyaya Sanhita has no akin provision or relative provision or similar type of provision in that code. Now you may ask me, what if it is not there? Because Supreme Court has already held 377 is against the Article 14 or even Article 21 also. Therefore, if it is omitted from the new code, what is the wrong in it or what will be its adverse impact? But there will be an adverse impact. That has been, the legal experts have been clamoring. Now look the judgment. If it is a free consent between the two elders, it is not an offense. If it is against minors, it will be an offense. It will be against the animals, it will be an offense. Now 377 is taken away, but POCSO Act is there, it is gender neutral. Therefore against the minor, by virtue of that enactment, POCSO law, even if 377 is not there, the offense can be booked against the perpetrator. Against the women, even 18 years more, under 375 rape, it will be a rape. Against her consent, she is an adult, but it is committed against her will, so law protects her interest. Okay? Now the only section left out is a male person who is an adult, against his interest, suppose an illegal and unnatural offense is committed, how is protected is the question. Because 377 is removed, there is no akin provision has been introduced in this, what you call, BNS. The vulnerable section is a male aged above 18 years, an adult male, against him an offense is perpetrated of this nature against his consent or will. What is the legal remedy for him? You have to think of yourselves, isn't it? If you find any solution for it, well and good. I have verified, but I couldn't get any. So that is why legal experts are now clamoring. The law is now lopsided in this regard. Total removal of 377, even though Supreme Court has carved out certain exceptions, those exceptions should have been put in a new section in a different format, but that is not there. Totally 377 has been removed, which may be a, what you call, create a unhealthy situations in the society in the coming years. Please read it. We are only discussing as an academic point of view. We don't know what type of interpretations will be given by different high courts and Supreme Court in future. But as the law stands today, we are only discussing. Please understand. I hope you understood this controversial aspect, 377, which has been removed totally. Then another important aspect is BNS. Of course, this is slide 13 and 13, slide 13 and 13. Next slide. There are section 33 offensive sections. Enhanced punishment is given. Okay? Previously, these 33 sections in a different mode, they are there in the IPC also. They have been now incorporated in another manner in another sections, but they are there. The only difference is all these 33 sections, enhanced punishment is prescribed. That we have to carefully observe. No, enhanced punishment is provided for. It's only for information sake I am telling. Next slide, 13E. Hit and run. I was discussing some time back. Hit and run cases were not, there was not a specific offense for it. Now, hit and run was made as an offense. Suppose if a driver hits a person on the way without stopping it and without reporting it to the police, he escapes it. Tomorrow if he is found out, he will be booked under 106(2). What this section tells us, whoever causes death of any person by rash and negligent driving of the vehicle, not amounting to culpable homicide, and escapes without reporting to the police, this is most important phrase, escapes without reporting it to the police officer or a magistrate soon after the incident, shall be punished with imprisonment of either description for a term which may extend to 10 years. Very serious offense it has made us. 10 years, and shall also be liable to fine. So if a person on the way hits and goes away, in future if he is found out and he is booked for an offense, he will have to undergo 10 years of imprisonment, up to 10 years. But this provision, as I already told, Section 1, if you have BNS, Section 1 says that the code will come into force as the central government notifies. Central government notification has been given, and with effect from 1/7/2024, the entire code comes into operation except this provision. 106 subsection 2 will not come into unless another notification is given. Why this is? It appears transport companies have given a representation. It is only my information, you can find out. A representation that under the umbrella of 106(2), tomorrow the transport operators also may be added as co-accused. Of course, the section is not that much clear, it only tells about the driver. But the transport operator may know that his driver committed an offense. He too keeps silence generally. Oh, you have escaped, don't tell anybody, keep silent. He will advise in normal course. Therefore, tomorrow, whether the driver informs to his master or not, there is a tendency of police booking a case against not only the driver, but also his owner of the vehicle. In sometimes the owner might not be knowing that his driver committed the offense. He was not an active abettor of the offense, but there is a tendency, they felt it. Therefore, the central legislation, it seems the reviewing this part of this provision, whether to keep it or whether to bring it into operation or to modify it or what to do, it is now we have to wait and see. But as of now, 106(2) is an offense pronouncing that a hit and run case, a driver will be booked for this offense. Please take note of it. Another important aspect. Punishment. An accused is undergoing a life imprisonment. He has committed a murder. He is undergoing life imprisonment. Already undergoing life imprisonment. That life imprisonment, the life convict we will call him, that life convict has committed another murder in the jail, or while he was in the parole, he committed another murder. So what is the at best punishment that can be given to him is, a life convict, if he commits a murder, the only punishment under section 303 was to give a death penalty. Is not it? But in 1983, a judgment has been pronounced by the Supreme Court. For your understanding, please note down Mittu versus State of Punjab. Very interesting point was raised. Mittu versus State of Punjab, 1983, 2 SCC, page 277. Next slide, 14A. This is the judgment, wherein the Supreme Court has observed, taken a cue from a very prominent, very renowned judgment. What is it? Bachan Singh versus State of Punjab, isn't it? If for a capital punishment, for a life imprisonment or a capital punishment for 302, Life punishment is the order and capital punishment is an exception only in the cases of rarest of the rare, isn't it? Rarest of the rare phraseology was introduced only with the Bachan Singh versus State of Punjab in the 1980 or 81, the decision. Then, applying the rarest of the rare principle to a life convict who committed murder, the punishment under 303 was only death. There is no other alternative. So where is the question of employing the rarest of the rare theory over there? There is only one punishment, that is death penalty. The Supreme Court in this judgment held that without giving an alternative scope, without giving a scope for punishing that offender with an alternative punishment, only prescribing one punishment, that is death penalty, is against the Constitution. This is what they felt, that the rarest of the rare theory pronounced in the Bachan Singh cannot be employed in case of 303 because the judge has no other alternative except to impose it is a mandate, is he has to be imposed with death penalty. This should not be. Therefore, they held that this 303 is ultra virus to the Constitution. Okay, so this, but it was continuing our statute book. Recently, what happened is in the present BNS, this provision has been taken away. Okay, but in another form it is introduced, that you have to please keep in mind. Section 104 of BNS has been introduced. Next. 104 has been 104, please note down. BNS has introduced section 104 saying that if a life convict has committed a murder, instead of imposing only death penalty, an alternative punishment is also prescribed. What is the alternative punishment? Is death or life throughout the natural part of the life. That is how they have introduced death or life imprisonment for the rest of his natural life. Why this rest of the natural life? Why? Because we have a provision in this CRPC 431, 432, etc. The government, after rendering a certain years of punishment, can extend the, what you call, he has to, remission can be given. For example, if a life convict serving for 14 years, the government may consider his good conduct, may extend remission. But that remission should not be applicable to this man. Who is this? A life convict who committed murder. So, alternative punishment is death or life throughout the natural part of his life. That is how now alternative punishment is available to the judge to impose. That is how they remediate the situation. So in the realm of section 303, concisely telling, by virtue of the judgment in Mitho's case, now a new provision has been introduced in the form of section 104 in BNS, stating that in such situation, death or life imprisonment, which means life for the rest of the natural life of the accused or convict. This is what the importance of this 104. Then the next important provision is 497. Okay, section 497 was the offense of adultery. Okay. Adultery was an offense for which only a man could be punished, and it was previously held as intravirus to the Constitution. But later, in the judgment, Joseph Singh versus Union of India. Joseph Singh versus Union of India, 2019 3 SEC, page 39. It was felt by the apex court that it was a discrimination. Only male could be punished, though adultery is committed by both male and female. It is a gender-oriented one. Therefore, it violates the Article 14 and other provisions of the Constitution. Therefore, they struck down 497 Now the thing is that but they held that if it is an adultery is committed, it can be a ground under civil law for a concerned spouse to obtain divorce or other related reliefs. But it cannot be made as a criminal offense. Understood? In a consensual parties or both, adultery cannot be made as an offense, criminal offense, but it can be a ground for the concerned spouse, wife or husband, to obtain divorce or other related reliefs in a civil law, but not under criminal law. This is the essence of judgment in Joseph Shining. 497 was taken. 497 till recently it was there in the statute book, but by virtue of this Supreme Court judgment, it is not being implemented, no punishment could be given. Now what happens is, in this one, in the BNS, 497 is totally taken away. 497 is no more prescribed even in a different mode or different format. So 497 we can call it a totally deleted provision from the BNS. So friends, these are some of the important provisions. And one more thing, the operability of operative sphere of BNS, that also I have to tell you. The operative sphere is such that it is essentially a penal law, isn't it? A penal laws always should be operated prospectively because they can't be operated retrospectively. This has been made clear. No one need to be worried. From the date of coming into operation of this enactment or code or Sanhita 17/2024, any offence has been committed, from that day only the new law will come into force. All the actions taken, prosecutions launched, investigations were under the way as per the old code, they will continue. They will not be affected because we have the provision ex post facto law. There can't be any ex post facto law punishing a person with retroactivity, retro-operability. That is not there in it. It has been enunciated in a number of judgments. One is, for your comprehension, AR 2004 Supreme Court case 2608. What was held is, taking a cue from Article 20, Subarticle 1 of the Constitution against ex post facto laws, held that no person shall be convicted of any offence except for violation of a law in force at the time of the commission of that act. This is most important. As on the date of commission of that act, what is the prevailing law? Under that law only he has to be tried and punished if at all his guilt is proved. This is the fundamental law of the land under Article 21. The new code BNS is also not an exception to it. To that extent, care has been taken. But the case law is AR 2004 Supreme Court, page 2608, Dayal Singh versus State of Rajasthan. Is only for your academic interest. So, this is the care that has been taken by the new code also. You will find the provision therein that the law will come into force prospectively but not retrospectively. One more section only I will tell and I will complete it. Again, attempt to commit suicide. Attempt to commit suicide hitherto was an offence. It was there, isn't it? 309. But that has been taken away from this new BNS, but put it in a different format. What is that format is? Attempt to commit offence per se is not an offence, but this attempt is made or ostensibly made by a person so as to threat or coerce another public authority. We will see sometimes a particular person going on to the rooftop and unless this is not done, that is done by the concerned public office, he will jump from the top of it and commit suicide. You will come across this type of cases. If such type of things are committed by any person, it will be an offence, isn't it? You have a democratic way of giving a representation or protest against the public authorities, but not by way of overawing them or coercing them. this is an offence now, it is made. I will give the relevant provision where it is made. So whoever attempts to commit suicide with intent to compel or restrain any public servant, it is only threatening the public servants from discharging their activities, from discharging his official duty, shall be punished with simple imprisonment for a term which may extend to so and so. So this is a new provision altogether. But attempt to commit suicide is no more an offence. Simple attempt to commit suicide is no more an offence. But it is coming into the new statute in this format. No one can threat the public servants with the threat of I will commit suicide if you do not do, or if you do it. That is not acceptable under the present BNS. So the attempted suiciders should be careful hereafter. Anything more? I have to learn from you 5 minutes. Anything you want to question me? If I have come across, I may try to share with you. Or any doubt left over, so far as I discussed with you, anything left over? If I am unable to, I could not able to share with you in a proper manner, I will try to repeat, but quickly within 5 or 6 minutes. That is there. That is why a series of provisions, though 124A has been taken away, another format has been introduced. If a person is overhaving the government or established government or sovereignty, and this UPA Act related provision is also, it has been incorporated therein. We have to see how it will be implemented. The date of commission has to be taken into 113, new one.
Yes, Your Lord.
I don't have readily the book. If any. Yes, terrorist acts.
UPA Act.
UPA Act.
And the police, Swapanda police has a right to decide under which UPA Act or this new act has to be prosecuted as per the explanation for this 113. What is the necessity of this 113? If already UPA Act is there, a special act. For what purpose this is incorporated in the present procedure?
Explanation has been given, isn't it?
Yes, Your Lord.
It is hereby declared that the offender not below the rank of superintendent of police shall decide whether to register the case under this section or under the unlawful activities UPA Act. A discretion has been given to the concerned superintendent of the police. Yes, that is
what is the necessity? Already a special act covers the same section. Why again
in the punishment, in the realm of course, I have not intensely studied this provision, whether in the punishment, mode of punishment or investigation to be done by a particular level of office, is there any difference between these two provisions? No. In the matter of providing punishment under this section and UPA Act, is there any difference?
No, Your Lord.
No. Thanking you all.